both of you. Okay, let's open it up for some questions. We've got about 10 minutes. So, yes.
So constitutionally, Hi, I'm Jenny Baker. I'm actually here representing a movement towards parental rights. One of the things we're trying to fight right now is Common Core. And when anybody that would like to help us on this, we need help, so please get with me afterwards. Anyway, so constitutionally speaking, what I understand about Common Core, and I'm actually asking to clarify because I don't know, and is that it didn't go through any like checks and balance system at the state level or the federal level, and that to me sounds like it's unconstitutional, but people are saying, oh, it's education. That doesn't go through checks and balances. So are they right? Or anyway, that's my question. Thank you.
There's two answers to that. They're not right theoretically or under an original interpretation of the public meaning of the Constitution when it was ratified. Education, for example, is not a proper sphere of federal power. I mean, if you were to look at the sphere of government power as a big circle, the states and the people under the 10th Amendment, sorry I keep going back to this, but under the 10th Amendment, anything not specifically given to the federal government and enumerated to it as a power is reserved respectively to the states or the people. And then in the middle of this big sphere is a little tiny sphere. And that's the enumerated powers given to the federal government. The fact is, education, public education in particular, is outside of the sphere of the federal government. So, yes, from a constitutional point of view, it's improper for the federal government to really exercise any power over public education. There have been Supreme Court cases that say the spending clause has been expanded so they can do a carrot and a stick approach to get us to do things, but it would be illegal under the 9th and 10th Amendments, even under modern jurisprudence, for the Congress to pass a curriculum, for example, here in Washington County. And then to answer your question, did it go through the proper legislative channels? We're guaranteed a republic in every state under the Constitution, and that includes separation of powers. And if the bureaucracy voted 15-0, that would be the state school board of education. In my mind, that's not quite appropriate.
Regarding Common Core, I would just say that personally, I think that I have concerns about how it seems to stifle innovation and force people into uniformity that's dictated from on high. That seems to me to be contrary to the American tradition and also to the separation of powers. And it seems to stifle the ability for parents on a local level to have a say with respect to special needs of their children.
So, in defense of our school children, would you, as county attorney, say, no state, no feds, you aren't getting into our land, you also aren't getting into our schools, your Common Core doesn't apply here in our county. Please back up.
The problem with that is that the county attorney does not represent the school district. Even though it's Washington County School District, they have their own attorneys, they have their own decision makers. So you'll have to be directing that question to the Washington County School District, because they're the ones that hire their attorneys and start their fights.
Well said, Brock. It's true, it's outside the purview and the authority of the county attorney's office to act. Although we would like to do something, we cannot because it's not lawful, it's beyond our authority. However, you can pursue it with the AG, because if it is unconstitutional, Sean Reyes could, for example, sue to have it removed. Or you could actually have standing in state court as a private individual and hire your own attorney. And we could explore that on the side. I mean, not if I'm county attorney, I'm just saying, Brock beats me up in the election and I'm around, I'll help you out. but yeah, great answer. But however, let me make one more point. The county attorney can provide moral authority by speaking out on these issues and taking a public position as a public servant.
Nina?
I always have questions.
Oh, one more. Oh, and then Nina, you.
Brock, you mentioned that you work for the county commission, that they're your employers. But we're the voters, so who is it that you really work for? And the reason I ask that is it goes back to this question I just asked a moment ago. It's one thing to take on the federal government, but we have government agencies in the state of Utah as well. And these government agencies, whether at the federal level or at the state level, exercise these legislative powers, the executive powers, the judicial powers all underneath one bureaucratic umbrella king who's going to do as he darn well pleases, and they set these rules and regulations with the force of law, and many of them are unconstitutional. Many of them don't have anything to do with anyone ever having committed any crime. They don't have a compelling public interest, which was the test that the Supreme Court put on, which was the way the Supreme Court let regulatory agencies through. And so, would you take on the Utah State agency and say, "I'm sorry, but you're doing this all over the state, but you aren't going to do it in the county of Washington because that's not right, and you don't have a compelling public interest, and our citizens down here don't want that"?
Well, I actually have done that in the context of the State Tax Commission telling Washington County several years ago that we needed to redo our tax assessment levels to bring them up to a certain level. And Washington County said, no, we believe that we're in the right spot. So there was direct litigation with the State Tax Commission on that issue. But back to your point about who does the county attorney represent? The county attorney, the two different roles have different policy responsibilities. As the prosecutor, it is my constitutional and statutory duty to make those decisions. They rest on my head. I make the calls, the commissioners don't. And the commissioners aren't really my bosses. The voters are. But this is the distinction with regard to the civil stuff. Somebody has to represent the people on making the decisions as to what lawsuits will we bring, what policies will we follow, and those people are the commissioners. They fulfill the legislative branch, and in Washington County uniquely, the executive branch. But by law, they are the ones who make the decisions on the civil side. So even though the people elect me and I respond directly to the people, the commissioners are who speak for the collective group of the people in deciding this is the lawsuit we'll bring. So if there is a regulation that Washington County is butting its heads against with respect to state law, then yes, I would bring a lawsuit against it, but it would be the commissioners who would say, this is what we're going to do. I have the moral authority to go to them and say, this is wrong, it's hurting our county. I would advocate that they take action, but ultimately it would be their call on the civil side. Nathan, do you want to say something?
In spite of them, three of them, so it's basically four people we have to convince to...
You don't have to convince me, actually. And the reason, no, you have to convince them, really.
And we understand these are budgetary matters, you get limited resources to address them.
Right. I mean, that's the challenge of government always, right? Trying to make do with the resources you've got and prioritize.
Great question. Yes, the county attorney is constitutionally elected. Our boss is the people. And Brock outlined the nuance of that with one of your jobs is to advise the county commission and all the county agencies. However, the ultimate bosses are the people. It's not the county commission or anyone else. It's the citizens of Washington County, and that's how it's set up. When we file prosecute cases rather, we're doing it under the authority of the state of Utah when it's a felony. However, when it's an infraction happening on non-city land, out on the BLM controlled areas, then you're acting under the authority of the county commission's legislative power to enforce that. So just adding on to what Brock said. However, there are opportunities and even times when I think the county attorney's office should take a pretty strong position against state agencies when they violate law. For example, you remember Attorney General Shurtleff pressuring people to basically chase down a family of a child who had cancer. The kid was, a judge found him old enough to make his own medical decisions. And the AG's office was unfortunately a bit too aggressive in my opinion. And I think the county attorney's office can stand up and say, you know, this is inappropriate. We're not going to use our resources to prosecute these parents because they have parental rights.
Any more? Nina said no. So we're going to move on. And so is there anybody who has a question or comment? First out.
Nate, I've had a chance to work with you on a case. You just reminded me a couple years ago. And my concern is, as a criminal prosecutor, I handle felony cases on a daily basis. And have you handled felony cases? How would you give me direction when I'm struggling with a case right now I have, which is an aggravated assault, burglary, and robbery of the first degree? How can I expect it, you know, to receive guidance from you? Have you handled felony cases?
No, I have not handled any felony cases, but I do remember a county attorney's race back when that was brought up at one point.
But no, I haven't. And I'll just be honest with you. But I can tell you that the man who hired Brock Belnap had the same level of experience that I did.
Any others? Okay. Well, what a great day